Education Committee needed the time to finish up work on an important bill they were holding a hearing on. At this time, I'd like to call on Senator Rhett to bring an invocation.
Thank you, Mr. Chair. Bow our heads, please. Oh, Lord, we thank you for this day, our daily bread, and opportunity to do the people's work here at the state capitol. Be with us and guide us, heart, mind, body, and soul, so that we can give a good account of ourselves. And we ask this through Christ our Lord. Amen.
Thank you very much. Do we have any judges in the audience? Judge Guy, good to see you. Anybody else? Always welcome. All right, we're going to make an announcement on one of the matters that is on the calendar. And that's SB 40, Senator Jackson's bill. This is sexual assault by persons with supervisory or disciplinary authority. We've had some input from the President Pro Tem's office to thinking along the same lines, and we're trying to meld those ideas with Senator Jackson's, and in a way that reaches all the pertinent places in the code. And I'll call on Ms. Beth Vaughn to maybe enlighten us a little bit about that, and then we'll continue on. Ms. Vaughn.
Thank you, Chairman. Working from the proposed sub for the bill that's on the agenda, LC 2371S, there were a few issues that came up in terms of putting this new offense of improper sexual contact by a person in a position of trust on par with what we have currently in the code regarding improper sexual contact by an employee or agent. So there were just a few areas of cleanup, including adding some language regarding including but not limited to a volunteer at line 75 to make sure that the first degree and second degree categories were mirrored. There is also throughout the code sections in which improper sexual contact by an employee or agent is listed, and this bill adding a new offense for such contact by a person in a position of trust to mirror that would also need to be added to those code sections that aren't currently in this LC number. That would include code section 1710-6.2. The bill contemplates that certain versions of this offense regarding persons in a position of trust would be subject to those mandatory minimum sentencing provisions in 17-10-6.2, but we don't currently in the bill add this new offense to the list of offenses in that code section. There's also an issue regarding the sex offender registry. Currently, improper sexual contact by an employee or agent in the first or second degree in violation of this code section, unless the punishment imposed was not subject to code section 17-10-6.2, is something that would put you on the list for the sex offender registry, potentially under code section 42-1-12. So to put that in parity with this new offense, we would need to go in and add improper sexual contact by a person in a position of trust to that list too. So those were just some of the issues that came up in Senate research.
So I'll ask you to get together with legislative council to continue to work on this, so possibly we can get it on probably Monday.
Thank you, Chair.
All right. Any questions from the committee or any comments? Okay. So Senator Jackson, come back to see us. We're working on it.
Thank you, sir. I appreciate it. Members of the committee, I thank you very much.
All right. Next on the agenda, we'll take up SB 429, Senator Ligon, Code Revision Commission, LC 338062.
Thank you, Mr. Chairman. Ms. Howard.
Yes, Come on up, Betsy. Anytime you're ready.
Okay, thank you, Mr. Chairman and members of the committee. I am working off of LC 33-8312S. There was a slight, there are a couple of errors, clerical errors, that we needed to correct, and that's the reason for the substitute. There were no substantive changes. But this is the annual code revision bill where we correct clerical errors, reauthorize the code, remove provisions that have been declared unconstitutional or suspended by other laws. And I'd like to turn it over to Ms. Howerton now to run through that with us.
Thank you. Ms. Howerton?
Sure. Yeah, as Chairman Ligon said, this is our annual code revisor bill. It's sometimes referred to as the commas and semicolons bill. So it makes no substantive changes at all. It's basically making changes to conform to sort of the style of the code and to keep it consistent. We also try to do things like update terminology. For instance, the term electronic mail is used throughout the code, and we're trying to update that to email to kind of keep up with the times, that kind of thing. Also, we correct names of entities that are referred to in the code change that are, say, a national organization, something like that, then we update that to try to keep it up to date. Just the structure of the bill, each section of the bill corresponds to a title of the code. So, for instance, that section 1 is reserved. That means, obviously, there's no changes or corrections that need to be made in that title. The Code Revision Commission approves 6 to 7 titles or volumes rather, that it reprints each year, and so we try to clean those up as much as possible. So, for instance, if you look in Section 7, there's a lot of changes in there, which is the banking area. We try to clean that up before we reprint the volume. The second thing it does, besides cleaning up things, is and more importantly, it reenacts the code as a whole. The statutory text, particularly the code section numbers, that kind of thing. And I don't know if everyone's aware, but the commission just right now has a case before the U.S. Supreme Court on the copyright of the code, and this revisor bill that you all are looking at figures prominently in that case. So it is, even though it seems, again, sort of related to commas and that kind of thing, it does have an important function. So we appreciate your consideration. And if there's any particular changes, I'd be happy to, talk to you about them or address them right now.
All right, any questions for Senator Ligon or Ms. Howerton? All right, do we have anyone signed up to speak?
That's it.
429. It's right here. There's no one signed up.
All right. Thank you very much. All right, what's the pleasure of the committee? Motion for due pass. Second by Kennedy. Any discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, like sign. Thank you very much.
Thank you, Mr. Chairman.
The next bill on the agenda is Senate Bill 435, Senator Strickland, and we have a late arriving, but we'll accept it, amendment or substitute LC 412415 ECS. Are you going to present? Why don't you go down there?
Ready for me to roll?
Anytime you're ready.
And I'm working off LC 412415 ECS. No substantive changes on this sub. A little bit of cleanup we did there, nothing substantive. I'll walk through this. This bill comes on behalf of Governor Kemp, but honestly more on behalf of the First Lady Marty Kemp. She has worked hard to address human trafficking in our state, really taking this on as one of her initiatives. And last year I brought Senate Bill 158, And part of what we did with that bill was decriminalize prostitution for minors, actually anybody 18 or under. And the goal there was to make sure that we're not arresting the victims of human trafficking. This bill goes a step further. This bill deals with how we address the records that victims of human trafficking have now and continue to have in our state. And visiting victims of human trafficking, one of the things that First Lady has learned, I've gone with her to some of these meetings, and these are people that are trying to find their way away from something that's all they know. Sometimes they rely so much on the person trafficking them, and they're taught to do that, and there's so many psychological things that go there. And then you have things like their record, and it's not just prostitution. There are other crimes that they get wrapped up in that the trafficker makes them commit. And they have a record with a lot of things on it sometimes, and they're trying to get away from this life that they're become dependent on, and then they can't get a job because of their criminal history. And so with this bill, what we're doing is there's two parts to it. Under Section 2, we're dealing with actually vacating a sentence, vacating and taking something completely off their record and even refunding them the fines that they paid as a result of that. The second part I'll get into in Section 3 of the bill deals with record restriction in itself. And I think I was out, Mr. Chairman, when y'all heard Senator Karen Shack's bill. These are apparently very similar bills. I think hers was a little bit more restrictive as far as dealing with the type of offenses that could be vacated. Mine's a little bit more open on that. But she's also worked with me on this. And but I think you guys already heard some testimony previously when I wasn't here. But I'll still go through this bill unless you want me to focus on anything in particular.
Go through the bill.
Okay. Under Section 2, as I said a minute ago, this deals with vacating a sentence. There's actually 3 different ways that you can deal with record restriction for human trafficking. And you could have and there's laws across the board like this around the country. You could say that you were going to vacate a sentence or restrict a record when the offense was committed under duress. And that's the hardest to prove, obviously, that you're under duress and you committed the crime. You can kind of go in the middle there and say that the crime was committed as a direct result of trafficking. That's kind of the more middle ground on that. Or you can just say that the crime was committed while you were a victim. So we take the second approach under the vacating part of this bill, and we say in Section 2 that if the offense was committed as a direct result of the defendant being a victim, they have a path forward with getting that crime vacated off their record. And you see under, starting on line 25, how that process works. And there's a form that will be provided, and there's a time period for when this has to be done. You see on lines 28 through 30. And this is 6 months following a conviction and sentencing for a misdemeanor, and at least a year after completion of a sentencing for a felony. And the logic there is, a lot of times when someone is having to deal with probation in particular for a sentence, they have certain programs they go through. So this allows the person to still finish what they're having to do as condition of probation. After that, though, they can go and file to have the offense vacated off their record. It includes them, have the offense vacated. It includes them having the GCIC submitted as part of this. And lines 36 through 41, actually going on down to 50, deals with documentation you can provide. You're not required to provide. Sometimes you don't have documentation showing that you were, that your offense was committed as a direct result of being a victim of human trafficking. And it creates a rebuttable presumption that you were a victim if you could submit that documentation. You get down further in the bill, starting line 54, with once you file this, there's no objection filed by a prosecutor, the court shall issue the order vacating the sentence. If there's an objection, then there'll be a hearing held within 90 days, and it sets forth preponderance of the evidence standard for the judge to look at if the prosecutor does object as to whether or not the offense ought to be vacated. And finally, this confirms under lines 67 through 70 that in addition to having the vacature, we're also going to have the record restricted as well as we do in Section 3 only. And lines 75 through 77 confirms what I said earlier about the fact that fines and fees, when something is vacated, are actually returned to that defendant. Under Section 3, this just deals with the record restriction part. And again, started with those 3 different ways you could address someone's connection, the crime they committed to human trafficking. And this is the most open way of looking at it, saying when you were a victim, if you committed a crime while you were a victim, you have the similar process we just set forth in Section 2 here, where you can file to have your record restricted. And the same process is in place, as you'll see, identical as far as what you have to include with your petition, what happens if the prosecution objects to it, if they don't object. And so you have the similar process that you go through here, and this just deals with record restriction in itself. And with that, Mr. Chairman, I will take any questions and dive deeper into any parts of the bill that you guys want to dive into this time.
I do have a few questions. Line 21, defendant convicted of an offense. There's no limitation on what type of offense?
That's correct. And the idea there is you have to show that the offense was the direct result of you being a victim. And so in the studies, and there's one study I have here that I've reviewed, it talks about, because in my mind, honestly, when I first thought about this, I thought about the prostitution charge we dealt with last year. But so many times the trafficker has people committing other crimes, and there's so many things that you may commit as a direct result of being a victim. And so we want to leave this open for anyone to file with any offense if they can show to a court, and of course to a prosecutor initially as well, that the offense was committed as a direct result of being a victim of human trafficking.
Well, so anything is aggravated as sex trafficking? I mean, if the victim was enlisted in the enterprise?
Well, I think that's where we will obviously trust that the prosecuting attorney would, I'm assuming, object to that. And then we obviously would have a judge with the discretion to not grant it in those situations. Even upon finding it by preponderance of the evidence, they meet the standard underneath the bill, they still have discretion. It's a may grant the vacature. So yes, we could create examples of how people could abuse this, but I think it's better to let people have their day in court versus limiting to the offenses. But we do have the discretion there by the judge.
I noticed on line 60, the court shall hold a hearing within 90 days for the vacatur petition. But on line 118, it says the court may hold a hearing within 90 days. Is that just a typo? Did you want to make them both shall?
Unless someone stands up and says there's a reason that should be may, I would think they both should be shall.
All right. You would entertain that as a friendly amendment?
I will, yes, sir.
Okay. What is a situation you envision someone would, instead of seeking a vacation of the sentence, just seeking a restriction?
You know, I think it's one of those situations where they may not be able to prove it was a direct result so much. I mean, sometimes it may be hard to have evidence of why you did something. The psychological impact that I can't relate to or understand of what these offenses do to people. It may be difficult to still prove that the crime they committed was really that related to being a victim. That's why we made it more open on record restriction, to where when you're the victim, any crime you commit, you get your chance to try to get it restricted. So I think there may be some situations that would fall under that section that would not fall under the vacature.
All right. Line 43, federal, state, and tribal. That's not, that would tie in any Indian tribe governing authorities or?
Over my head, I'm assuming.
All right.
And those, of course, are examples of what you could use as documentation to show your status as a victim.
All right. Any questions for Senator Strickland? All right. Thank you very much.
You have somebody sign to speak.
All right, Kim Fry, come on up. Good afternoon.
Good afternoon. I'm one of the volunteer lawyers who are down here for GACTL this week, Georgia Association of Criminal Defense Lawyers. So, having represented people who have been victims throughout their life and also defending people who are charged with human trafficking, I've been close and personal to some of these things. We are absolutely in favor of this bill. The only thing, and I think the Senator Strickland has talked to us about is lines 31 through 35, where it says that the petition shall be submitted with a copy of his or her criminal history background check. That can be done. There's a lot of separate codes to this. Typically, though, the code that you're going to get when you go to a police station or something like that might not be the full judicial code. Also, the concern is, even though the petition is filed under seal, court personnel would have access to it, and there are actually felony sentences for sharing some GCIC information. So date of births, social security numbers, identifying information could make this person a second victim. So that's really the only thing that we would ask, is that let them file the petition. I think there were some concerns from Senator Strickland that a judge would not be able to make a decision if there was no criminal history record. But I would be hopeful that once a district attorney got the petition filed, that they would file their C code, which is the judicial code. They'd want their full C code GCIC, or also they have access to NCIC, the National Criminal Information, to fulfill the other part of this, which is no warrant for them in a jurisdiction in another state. So we would expect that a district attorney who consents or one who doesn't respond would do that. And frankly, a court can order that, can ask the DA to at least get them that information, because the court typically does not have access to that. But it's similar to when a court asks for the jurors to be screened through GCIC to determine if there are any convicted felons on the jury pool.
So mechanically, my understanding is you can get a criminal history on yourself,
You can.
but it's not complete. It doesn't show everything that might be out there, like arrest.
Correct.
With no adjudication.
What it may not show is some first offenders, and some C code shows everything. Diversions, dismissals, it would even show this and would say that it has been vacated and under seal. It would show the actuality of what that GCIC shows is everything that's happened. But the different codes, an employer gets a different code than the own person gets a code, and it is very difficult for a private citizen to get their own NCIC.
So are you saying that it should specify which level of background the petitioner has to provide?
I think the petitioner could file their criminal history as they think it is. The document is the only thing we're concerned about, so that they do not become an additional victim of someone of ID theft, because those GCICs are protected. To even have access to a terminal requires a 2-hour class and is subject to a felony punishment if you access it.
So what I'm getting at is that petitioner might not be able to give attached with the petition the full history.
Correct. And we're going to have to leave that on our prosecution to be able to do that, because they're the only ones who can access the full history, including the national history.
All right.
So even if you submitted it and the judge only looked at that and the prosecutor didn't say anything, the judge still may not have the entire history to look at when they're making the decision. So it's just a little bit of a hurdle, that's all.
All right. You think the participants could work through the process without any changes in the bill itself?
I think if you literally just took out Section C and let them petition, I think the way our courts work, it would take care of itself. I don't expect there to be a run on these petitions. I don't expect that a judge would not take it very seriously. So I think that would be ordered and would be done. I would also expect that if a district attorney is going to vacate someone's entire criminal history, they're going to take a look at that before they do that. If they're going to record restrict someone's entire criminal history, we're about to have a discussion about a record restriction bill, they're going to be very concerned about that. So I don't have the same concerns that Senator Strickland has as to the judge having that with no other input.
Well, a petitioner could apply for her own record, attach whatever she got, and then the district attorney could go a step further in maybe objecting to the petition by diving deeper into the record and even going into the NCIC.
Absolutely, it just doesn't protect that victim from anybody in the courthouse or any accidental, inadvertent release of that.
And what, other than a seal of the record of the petition, would you, what better method is there?
I think if I were in your position, if I'm thinking about it, I might just ask the district attorney to have another line in there where the district attorney will provide the GCIC, NCIC will respond to the petition, not saying yay or nay, but just will respond with the GCIC. But I don't think it has to be filed, is the whole thing. Because when we file something, we make it a public record.
All right. Any questions? Thank you very much.
Thank you.
All right, there's no one else signed up to speak to the committee. What's the pleasure of the committee? I think we need to take up the friendly amendment first. But we need to have a motion for.
I'll move to pass.
Do pass. Is there second by Parent? Now, any discussion? Yeah, why don't you do that?
Under line 118, where it says may, before may will be struck and it'll say shall. Stricken.
All right. Is there a second?
Second.
Discussion? Hearing none, all in favor of the amendment signify by saying aye.
Aye.
Opposed? All right. The committee substitute has been further amended for the purpose of creating a new substitute. Is there any further discussion on the main motion? Hearing none, all in favor of the amended SB 435 signify by saying aye. Aye. Opposed, like sign. Thank you very much. This brings us to the last matter on the agenda. Senator Anderson, SB 288. This is for hearing only. You want to come forward? Anytime you're ready, Senator.
All right. Thank you, Mr. Chairman. Good afternoon to you and members of the committee. This is a bill that I pre-filed that has bipartisan support, Senate Bill 288, and I am operating from the version LC 412171. This bill requires that an individual's criminal history record information be restricted when, one, the charges relating to the criminal history record information has been dismissed or null prost, learning my new legal terms, or there's been a disposition of the charges other than a conviction. And those are shown in lines 14 through 51. Excuse me. Lines 52 through 80 actually maintains current law that allows for the restriction of criminal history record even when there is a conviction. It's a lot of striking in here. So lines 81 through 134 strikes the law that will no longer apply or be applicable when this bill is passed based on lines 14 through 51. Lines 135 through 180 maintain current law, except with the exception of the revision in line 158. That is pretty much a code cleanup and to delete any outdated reference. Lines 181 through 200 are included to strike lines 193 and 184. So that's to ensure that there is a bright line rule of record restriction without the exercise of discretion. Lines 201 through 235, it strikes the current law that would no longer apply. And then lines 236 through 257 are included to re-letter the code section pretty much for organization of the bill. So in essence, fact remains that a criminal history record imposes lifetime barriers on people for employment, for housing, and for other opportunities. This bill would bring about a great economic change to Georgia. Communities will be safer, and the economy would improve so that those who have been rehabilitated can have a second chance to take care of their families and be reunited into society after having served their sentences. If there are any questions, I'll take questions.
Any questions from the committee? There's a lot of current law being taken out in this. What would you summarize the main change?
So my understanding of the main change, and I'll take some help from Julius if I need it, but my understanding of the main change would be that this would be a restriction of records that would allow people to, again, apply for jobs, have employment, housing, and create, a life for themselves. And I think a lot of the restriction, it would be outdated if the bill passed. It's not stricken yet, but it would be.
All right. Thank you very much. Don't see any questions, but there are, there is a question. Senator Jones.
Thank you, Mr. Chair. Well, I guess one of the changes would it be an automatic record restriction once the case is dismissed or non-prost? Is that one thing that we're looking at, that no longer you have to file, or that the GCIC has to wait for notice from the prosecuting attorney or things of that nature?
Yes, to my understanding it is.
Okay.
And I read that on line 4, and I forgot to bring that out.
Mhm.
Thank you.
All right. Any other questions? All right, we have a few people signed up to speak. Brenda Smeaton, hope I got your name right. Come on up. You're with the Georgia Justice Project?
I am. I'm the legal director of the Georgia Justice Project. Thank you for having a hearing on this important issue. Georgia Justice Project, if you're not familiar with us, over the last 15 years, we have focused most of our efforts on representing people that have criminal records and assisting them to the extent possible under Georgia's current law to clean up their record, and so they can get a job and move on with their lives. But the reality is that the vast majority of the people that come to our office and come to these record restriction summits that have been being held around the state for the last 3 years can't be helped under the current law because it is so limited. Also wanted to mention that I'm here on behalf of the Second Chance for Georgia campaign, which is a campaign supporting expanding restriction and sealing, and so far only over 70 organizations and congregations have signed on to support this issue. So unlike in 41 other states, in Georgia, almost all convictions stay on your record for life. The only convictions that you can get off now are certain misdemeanors if you were convicted of the offense before you turn 21. So right now there are 6 pending bills, either in the Senate or the House, to expand access to restriction and sealing. So there's a lot of momentum growing. Although we haven't been involved in drafting this particular bill, GJP supports all efforts to change the law to expand access to restriction and sealing. A couple of points I wanted to make. One, that this issue is not new. It's something the legislature has been working on for a number of years. The current draft of the law was enacted in 2012, went into effect in 2013, but that was certainly not intended to be the end of the reform. There's actually a 2013 Senate study committee that looked at the issue and recommended automatic sealing of certain convictions after a number of years and a demonstration of demonstrating rehabilitation. Also, in 2018, the Council on Criminal Justice Reform recommended expanding access to restriction and sealing for convictions. So Georgia is falling further and further behind. In a report that came out just last week, the Collateral Consequences Resource Center highlighted Georgia as one of 3 states that have taken no steps in recent years to expand access to restoration of rights and status and access to employment for folks with a record. So a lot of states, just last year, 31 states expanded access to record clearing remedies, and in a tight labor market, many of these reforms have been driven by employers and by chambers of commerce and the need to fill open positions and allow people to advance in their careers. So in the years that I've been doing this work, I've really seen our client base change. 10 years ago, a lot of people were coming in, they couldn't get any job. That's not the case anymore. People can often get a fast food job or a job in landscaping or a warehouse. Now our clients often, they've done something to further their education, they've gotten a degree, they want to get a higher paying job that pays a livable wage, and they can't move into these middle skills positions because of their record is holding them back. So there's good data that shows that this is good policy. As Senator Anderson mentioned, the economic impact is huge. Nationwide, the estimate is about $78 to $87 billion in GDP is lost because of unemployment and underemployment for people that have a criminal history. There are studies that show the likelihood of employment the first year after expunging a conviction goes up by about 11% and wages up by about 22%. And another study found increased earnings 1 year after expungement, and this is about an 8-year-old study, of about $6,200 in just the first year. So that could be a significant increase for a family in their income. So the benefits of expanding second chances are clear. We're glad to see a growing momentum and interest around this issue, and certainly look forward to being part of the conversation about how to do that.
Senator Cowser.
Thank you, Mr. Chairman. You said that Georgia does not currently have a provision for restricting convictions, or our old term expunging.
Yeah, so, well, one, they don't call it expungement anymore because we don't destroy our records. Law enforcement always has access to them. So we can restrict and seal most non-convictions. There are some exceptions. And then certain misdemeanors, if an individual was below 21 when they were convicted. That's all that you can get off your record currently.
I thought you could file a petition with Superior Court, claim that it was the interest of justice, and the DA could respond if they wanted to. Is that procedure now defunct?
I mean, you can always try anything you want, I guess, but that is not a commonly used procedure. That's not something that we do.
Okay.
All right. Any other questions? Thank you very much.
Thank you.
Excuse me, if you have any, research or information you'd like to provide to the committee, feel free to do that.
I have a bunch of packets with me, and I'm happy to give them to you.
Good. Thank you. Don Plummer. Good afternoon.
Good afternoon. My name is Don Plummer. I work for the Episcopal Church in Georgia, but I'm here representing them and also the newly formed Georgia Interfaith Public Policy Center, which represents all three Abrahamic faiths, Muslim, Jew, and Christian. And the idea is that we wanted to have a way that we could make these kind of presentations, be with you as you consider changes in laws, from a perspective of what our faith tells us to do. We've been very pleased, very gratified to see the changes that Georgia has made in its treatment of people who are marginalized. Ban the box activity was one that was very, very helpful. We've also been greatly gratified by the Grace Commission and its activities and the trying to help young ladies and young boys too get out of a life of crime. We see these record restriction legislations as another step that can be taken in that area. I guess if we were a political organization, I would say that our platform is love, mercy, and justice. That does inform our position on all of these issues. And so what we would like to do is to be the voice of people of faith in Georgia, helping them understand both what the issues are and also responding with what their positions might be. So today we heartily support all of the efforts to restrict legislation. We believe that our Creator continues the creation all through our lives, and that we are not the worst thing we've ever done, and that we continue to grow in grace. So those are the things that we would like to posit.
Thank you very much. Brendan Spar. Good afternoon.
Good afternoon. My name is Brendan Spar, and I represent the Greater Gwinnett Reentry Alliance. We are made up of about 24 reentry service providers in the Gwinnett County area, and our providers are kind of the boots on the ground for the men and women that are coming out of jail and prison to Gwinnett County. What our providers are finding is they're working with these men and women that are coming out, and they're going through their programs, they're being successful, and they need to transition. They need to enter society after their reentry. And what they're finding is the background is holding them back every time. They want to put them in stable housing and get them out of the transitional housing, or put them in a stable job and get them out of the transitional job. But the employers or the housing providers are unwilling to accept them with that criminal record. Georgia's been leading in the ban the box that former Governor Deal has put through, but still there's a bias with these housing providers and these employers. Despite ample education, second chance month proclamations from Governor Kemp, we've tried everything to get these employers. Even the Society for Human Resource Management has policies for individual assessments where you look at someone and take their whole account, their rehabilitation, how long it's been since the crime, all these factors into account. The employers and housing providers are still having this bias. So what we believe is that this bill would do is take the bias out of the equation. If they can't see it and it's not relevant to the job, then does it really matter? And this would help the providers actually transition someone out of their care and back into society. So reentry will turn from reentering society to entering society once they have actually transitioned out of the service provider. They'll have a pathway to then get stable employment and stable housing. So our providers are asking for this so that they don't have to continue to care for these constituents for the remainder of their life, really. And while it could be 10 or 20 years removed from the crime, there still is the stigma and the bias.
Thank you very much. Mel Wright. Mel Wright. Alex Cammerdale.
Good afternoon, committee.
Good afternoon.
My name is Alex Commerdale. I'm a policy analyst at the Georgia Budget and Policy Institute. And I want to thank all of you for listening and hearing on this legislation, as well as Senator Anderson for bringing this forward. We strongly support expanding record restriction in Georgia. And a lot of what I'll say will also mimic what my friend Brenda Smeaton mentioned earlier, as we are part of the Second Chance campaign as well. I'm just here to offer critical points that reflect some of the data that we've been observing that explains the undeniable need to expand record restriction in the state of Georgia. We strongly believe that amid all the conversations regarding public safety in the state, that expanding record restriction is one of the most significant and also the most cost-efficient ways to improve public safety. Far too many Georgians are denied work opportunities as a result of a criminal record on their history. And while opportunities to seal records and create a clean slate exist in other states, Georgia still has one of the most limited record restriction laws in the country. There are more than 1,000 sanctions in Georgia law that point to a criminal record as a reason to prohibit somebody from gaining access to a meaningful job. Employers routinely screen out perfectly qualified applicants because of their criminal history. And access to criminal records continues to shrink jobs access and the number of talented individuals available to employers. Currently, at the end of 2019, there are roughly 230,000 unfilled jobs in Georgia. We're also experiencing a concerning decline in labor force participation rates, that is, the number of workers that are available to employers in the state. We're also concerned about some of the racial equity and the outsized impact on Georgians of color that are imposed by the criminal record, by a criminal record. So, for example, Black Georgians are already treated disparately by the criminal justice system and overrepresented in prisons. And this makes the burden of a record weigh most heavily on Black communities. The Equal Opportunity Commission finds that the use of convictions as a screening tool does carry a disparate impact because Black Americans are convicted at higher rates. Further, we know from mounting evidence that Black job applicants with a record are half as likely as similarly qualified applicants, white applicants with a record, to receive a callback or a job offer. In Georgia, the unemployment rate for returning citizens is already 15%, nearly 5 times higher than it is statewide. Expanding the expungement and expanding restriction and ensuring the inclusion of returning citizens leads to increased earnings, increased tax revenues, and avoided costs of reincarceration, as mentioned earlier. Again, employment remains one of the most significant ways to avoid recidivism and improve public safety. Each formerly incarcerated Georgian who was locked out of work due to a record lost about $36,000 in wages in 2019 alone. These lost wages amount to an estimated $2.6 billion in wasted spending power just in the state of Georgia. So I'm just here to please ask that you consider these facts as you review SB 288 and other record restriction legislation, which will not only jumpstart economic opportunity for returning citizens, but also create a ripple effect that will boost prosperity for all Georgians. And thank you again, and I'm here to answer any questions if there are any.
I don't see any questions. Thank you.
Thank you.
Speaking, Kim Fry.
Obviously, the Georgia Association of Criminal Counselors is also supporting record restriction for our clients. Have people call me all the time wanting to know how to expunge their record or clear their record, and I have to tell them that this is truly your permanent record and you can't be helped. One of the number one things on there is that cases that were never charged or never completed as a conviction will be automatically restricted. Since the last bill, only things since 2013 have been. Before that, it's all prosecutorial discretion. So a very light story, my dad came to me a few years ago. He had a 40-year-old open charge that was on a dead docket for purchasing a gun at a pawn shop, and he got arrested for possessing a stolen gun. They dead docketed, the DA dead docketed at the time. He was 40 years old. He could not get a carry permit. He's like, Kim, I'm 65 years old. I might want to carry a gun again. He'd been a police officer long before. And I said, well, I don't know what I can do, Dad, but I know Vic Reynolds was the DA at the time, and I went over to see him since we're friends, and he did it for me. He took care of it. But that's because my dad knew me and I knew Vic. That was the only way that that happened. But so it has lots of ranging consequences for a lot of people. A lot of people who hadn't done anything for 40 years in their life and had a charge just sitting out there. So,
How many Georgians have a criminal record?
well, that's an interesting question.
4.2 million
4.2 million.
We currently,
out of 11,
right,
almost half.
1 in 18 people in Georgia currently are on probation, in prison, or on parole. When you ask a company to come move here and hire people, and you tell them that almost half the people in your state have a criminal history, that's going to make a lot of businesses not want to come here.
All right, there's a question, Senator Strickland.
Thank you, Mr. Chairman. Under this bill, we're talking about GCIC earlier on my bill. When someone pulls it with the law enforcement code, would this still show up, or would this completely restrict it?
It will still show up
Okay.
for law enforcement and judicial system.
So when an employer, if they're using a proper code, though, you wouldn't see it there, but the law enforcement would still see where it was restricted. Okay.
Correct.
Yes.
Thank you.
You're welcome.
All right, thank you. Didn't see any prosecutors sign up. I don't see any prosecutors here.
It's after 5.
All right, nobody else has signed up. Anybody wanted to be heard? All right. Yes, ma'am.
You're welcome.
Step forward.
Good afternoon.
Good afternoon.
My name is Karen James, and my son is a returning citizen. We are 1 year and 1 month in. He has 3 years of college, and he was in for 6 years for a nonviolent offense. He is now working probably 3 jobs to piece together a livable wage. He's still at home with us. He would love to move out. He's 31 years old. He has a daughter. But the way that things are now, because of his record, even though it's recent, it's difficult to get a job that would pay above minimum wage. And he tried to get housing for himself, and he was unable to. And they told him it was because of his record. So it's the question is, what's the reason for going to jail or prison and serving time, and then you come out and you are still plagued by what you did in the past that you supposedly served your time for. We really need to look at, as the pastor said, we all have done things that don't necessarily follow us for the rest of our lives. And so we need to give people an opportunity to change. We do a lot of trying to keep him motivated to continue to try. He doesn't want to go back. But when you continue to run into barriers, fences that are put up, walls that are put up, it's very disheartening. And I just wanted to just share that personal story.
Thank you very much.
Thank you.
Okay, I see no further questions. No one else asking to speak. We'll be adjourned. Thank you very much.
Thank you.